Hi.
Good evening.
First of all, thank you for giving citizens a chance to talk about this bill. I think it's an important bill. It's going to make a drastic change to Georgia's laws. My name is Ed Stone. I'm an attorney. I've been an attorney for 21 years. I was formerly a law enforcement officer. I did that for 12 years, most recently in Union City, which is South Fulton County down by the airport. I have made thousands of arrests. I have multiple times made arrests as a private citizen, and I have to say I sit here seething just a little bit listening to the characterizations of somebody who would do what I view and what the Georgia Supreme Court has viewed and has stated is the duty of a citizen and a good and honorable thing. House Bill 479, I'm strongly opposed. In fact, I think we should call it the Make a Citizen's Arrest a Felony Bill. As Madam Senator pointed out, Georgia will be the only state in the nation, if this bill passes, where one has no way to detain a criminal, no matter how horrible the crime, until the police arrive, even if that's just 2 minutes later. This is bad public policy, and it's bad public policy because it encourages criminals, because it makes escape an easier prospect for them. We heard about Chick-Fil-A. The reason people are getting emails about Chick-Fil-A is, ironically, that Chick-Fil-A robbery at Colony Square happened on the very afternoon that the House passed this bill. And what you're not being told is that force was not used to prevent a forcible felony in that case. The robber stopped the forcible felony on his own. He went outside, and he was chased down by Georgia citizens, one of whom had a firearm. Now, this is important because we're being told that people are blatantly and intentionally not understanding what happened there. But it's blatantly and intentionally misrepresenting what happened. Nobody stopped a forcible felony. Nobody prevented a forcible felony. The statute you just heard quoted was OCGA 16321. That statute allows one to defend oneself or another, a third person, if you are defending yourself against the imminent use of unlawful force. Imminent is a very important word. It, in plain English, means just about to happen. Something that has already happened, something that the bad actor has stopped doing, and something from which he is fleeing is not imminent because it is not just about to happen. And by taking him into custody and holding him for the police, you are not preventing the forcible felony. You're detaining him because he already committed the forcible felony. Citizens' arrests, by the way, are not unusual. They're very common. When I was a police officer, it was a very common occurrence to take into custody people who'd been arrested under the citizens' arrest statutes. I spoke with Lee Weems, the chief deputy of Oconee County, because it's been a long time since I was a law enforcement officer, and he assured me that that is still a common occurrence, and he estimates it's multiple times daily in the state of Georgia. It is incumbent upon this body to know what the current law is, and especially to know the consequences of any legislation that you vote upon will be upon the law. We heard earlier about the Robinson case. I ask you, please read it. As Representative Reeves has said, it's very short. You can read it for yourself. In that case, the homeowner did make an arrest. It wasn't an issue in the case. As you might guess from the title of the case, Robinson versus the state, the parties to this case are Robinson, he's the burglar, and the state, that's the state of Georgia. The homeowner wasn't a party to this case. The validity of the arrest wasn't an issue in this case because we have a citizen's arrest statute. And as the facts were recited to you, the homeowner actually saw this burglar committing a burglary in his presence. The citizen's arrest statute says you have the right to arrest him. The burglar attacked him and bit him. The burglar was charged, among other things, with battery, which is a violent crime. On appeal, and keep in mind the Georgia Court of Appeals only takes the issues that are appealed. The homeowner wasn't appealing anything. The burglar didn't appeal the validity of his arrest. On appeal, the burglar said the judge should have given that jury a jury instruction on self-defense. I had a right to defend myself from that homeowner. And the Georgia Court of Appeals said, yeah, no, you don't. And that's where they cite these statutes. And they did say the homeowner was acting legally in defending his home and therefore you, sir, are not entitled to a jury instruction under 16-321. There is nothing in that case that says you can go chase down a criminal and arrest them when the unlawful force is no longer imminent. I encourage you to please do your own homework and read those self-defense statutes starting at 16-321, because those are going to tell you what you're voting on. Now, if you're being told those are going to allow you to chase people down and arrest them, then I'd ask, what's the point of this bill? What does it accomplish? We're repealing the citizen's arrest statute, but you're still going to be able to make a citizen's arrest. That logically just doesn't make sense. You will not be able to make a citizen's arrest, and that's because the statutes for citizen's arrest are the legal authority for an arrest. False imprisonment is a statute in this state that is a felony, and it consists of someone who detains a person without legal authority. The legal authority for an arrest comes from the very things that this bill repeals in Section 2, which are OCGA 17460, OCGA 17461, and 62. Police officers' powers of arrest, by the way, are in 174-20. Those aren't being repealed. But as you know, when a police officer, a city police officer, like I was myself, is outside of his jurisdiction, and he makes an arrest, as long as it's consistent with the statutes on a citizen's arrest, the court says, well, police officers are citizens too. And so this is a valid arrest. So this bill, or whoever authored that section of the bill, lines 44 through 51, knew those officers would no longer be able to make a citizen's arrest. But we're being told as a non-police officer, don't worry, you'll be able under the self-defense statutes to go ahead and make one. I've also taken a look at the case law on legal authority for an arrest. And I will tell you that in every case, the courts cite to statutory circumstances, which are 17-460, 61, and 62. In fact, in just a few minutes, I pulled several of those cases and cut and pasted them here. Mr. Chairman, could I pass these out? I've got enough here for everyone.
Yes, we'll have somebody come grab them from you.
Thank you. You'll see at the top of the page the false imprisonment statute, which is important because detaining a person without legal authority, and the legal authority is being repealed by this statute, means 10 years in prison. If you use a firearm like one of the persons did at Chick-Fil-a, that's aggravated assault. That's 20 years in prison. If you move the person, like for example, from your front yard onto the porch to wait for the police, that is an additional element which constitutes kidnapping. That's the only difference between false imprisonment and kidnapping. Asportation, you've moved him no matter how slightly. That's 20 years in prison. And if the criminal is injured during a kidnapping, that's life in prison. So it could very well be that once this bill is passed, the people who do what most of us would view as a good, honorable thing are actually facing more prison time than the criminals that they arrest. I'd like to address one last thing, which is justification, 16-320. And we're being told, well, the justification statute somehow will still cover us and somehow you'll still make an arrest. It still leaves that logical leap here that, you know, we're saying you can't do a citizen's arrest, but somehow we're still going to be able to under 16-320. Under 16-320, number 4 is when the person's conduct is reasonable and is performed in the course of making a lawful arrest. Well, there's a reason that one wasn't being cited to you, because it's no longer going to be a lawful arrest. So we're being told when that number 5 would apply when the person's conduct is justified for any other reason under the laws of this state. There won't be any other reason under the laws of this state. You're repealing those statutes. As you can see from the handouts that just came around, every one of these cases cites to, for police officers, 17-420, or for individuals, 17-460. You can see that under the heading case law on the legal authority to detain a person says the only legal authority is contained in OCGA 17-460, 61, and 62. And that Supreme Court case that says it's the duty of a private citizen to make an arrest is cited directly under that. But the Kroger case is the case in the block quote below that. You'll see in the last line, basically the only justifications for arrest that keep you from being arrested for a crime or sued in tort are 17-420 if you're a police officer, or 17460. There it is in black and white. That is from the Georgia Court of Appeals. And if you continue to page through, you'll see one case after another where they refer to statutory circumstances applicable to law enforcement officers or private persons on the next page. Federal case law also cites to Georgia's citizen arrest statute. Now, that was under the old numbering system, but that is today's 17460. And then, of course, the case at the bottom of the next page is Bacon versus State, which is the reason why lines 44 through 51 are part of the bill. A municipal officer outside of the city limits could no longer make a citizen's arrest because it won't exist anymore if you pass House Bill 479. And anyway, there's another case there to follow on. I encourage you to please look at those. Number 6 under 16320 is all circumstances which stand upon the same footing of reason and justice as those enumerated in this article. The article is not just that statute, it is the entire justification and self-defense statutes, but I encourage you again, please read them. They are not that complicated. They are not. The word imminent, just grab a dictionary if you don't know it. It means something's just about to happen. It doesn't mean that you can go and make an arrest after it's no longer happening. If I were to threaten, I'm not threatening anybody here, but if I were to threaten a member of this committee with a weapon and you shot me dead in front of all these witnesses, you would have a justification of self-defense. He was threatening me with imminent death or bodily harm, and I exercise self-defense. If, however, you didn't shoot me dead and I just left and you hunted me down in the parking lot and shot me in the back, that is no longer self-defense because it's not imminent. And that is the difference between the footing and circumstances it's referred to in justification for the self-defense statutes and for a citizen's arrest. You'll notice that lines 44 through 51, some of the language for police officers has been stolen directly from the citizen's arrest statute that you are repealing if you pass this bill. And that is because that is the basis for an arrest. It's good public policy, and it's good to let police officers make an arrest that citizens can make, of course, if they're outside of their powers of arrest as a police officer. But it is also a good thing for citizens to do an honorable duty of making a citizen's arrest when they witness a crime. You know, I'll give you an example. When I was a police officer, I pulled up to a store where somebody had pushed a little old lady onto the concrete sidewalk and shattered her hip. This lady's laying there screaming. There were plenty of full-grown men who had witnessed this. They were standing around. They were still there. None of them had grabbed this guy. And I remember thinking to myself, I was disgusted. What a bunch of cowards. You know, they wouldn't even grab this guy for 2 minutes was my response time. This guy got away. To this day, I have no idea who he was. But if you pass House Bill 479, that will be the only acceptable course of conduct, is to allow the person to escape and hope the police get there quicker than 2 minutes, I guess. Because to do otherwise risks 10 years in prison at a minimum. That concludes my comments on it. Please, please, please read the citations that have been given to you. And are there any questions I can resolve while I'm still standing here?
Any questions for Mr. Stone? Senator Parent?
Your name in the beginning.
I'm sorry, my name is Ed, E.D. Stone, S-T-O-N-E.
Thank you. And are you representing yourself, or are you affiliated with any organization?
You might recognize me from an organization I used to come here and speak on behalf of pretty frequently, but I'm no longer in a leadership position with that organization, and I'm not here on behalf of any organization, just myself as a Georgia citizen.
Thank you.
Any other questions for Mr. Stone? Thank you very much.
Thank you for the opportunity to speak.
I'm going